Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will
relevant.
bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
As the agent for Payne, Ansley, John Milton, you are indicating to me that you're quite familiar with Payne, Ansley, John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Payne, Ansley, John Milton, as
Okay.
written in all capital letters.
All right, and you understand for my purposes, that language doesn't make any sense. So
No, I do not.
I understand. Okay, well, I'm telling you that, and so I am, until you disabuse me of the motion, or the notion, I am inclined to believe that you are both the agent and the person, so. And it's in
I'm
all
not a
caps.
person. I am one of the people. Thank you.
Okay, thank you.
Okay, thank you. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Not a person, I'm one of the people. I thought those voices were in my head, says Laura. Yes. We have to do this one too, because
Did the defendant find out how the FBI finds people in this case?
Oh, she found out.
she found out. All right, welcome back. We are back. Power to the people. And we're back. We're back for a little bit of lighthearted fun today.
Remember in the beginning when we started 110 years ago?
110 to the day. 110 years ago today. Time flies. All right, welcome back. How's everyone's lunch? Was it fabulous? Why is my camera so dark? Did I make it this dark? What did I do that? Okay, hold please. We're gonna fix this just a little bit. Too much white. Let's see. Just go right there. That's good. We'll keep it right there. That's a little bit better. I heard the intro and I was like, wow, RA is in my team meeting. Yes, it is. Suddenly it looks like daytime. The lights are on, but nobody's home. Welcome. It is Wednesday afternoon. The court case today, the Judy Church court case, which is nearing the end of the whole proceeding, is done for the day. The state has run out of witnesses. They have one more to come in tomorrow. That's the ME. And then we're going to be on to the defense tomorrow as well. So we're going to get to do a little bit of lighthearted court hopping today. I'm not going to start another case until this one's over. But let's see. We've got a little bit going on up in Thurston County, Washington, which is always a fun place to visit. That's why we played the soundbite that we did. Let's see what's going on up there first. Oh, by the way, I don't know who on the internet. So one of you needs to take care of it. I'm not sure who it is.
State requests a bench warrant in this case, Your Honor. It looks like there have been FTAs in the past.
Failure to appear, bench warrant. We showed up just in time.
I do see a number of prior FTAs, even just in this case.
We're going to go to Judge Simpson here in a minute. He's just on break.
Also, considering the nature of the charge, I'm going to do 750 cash or bond. Brings us up to the 10:30 calendar, and actually, I believe everything has been addressed on the 10:30, which closes out this morning's calendar.
All right, so they're done. We're going to jump up to Simpson, who is about to start his next block here in just a minute, I think. Got one in custody waiting. Not sure what that is about, but we'll see if we can find out here in just a minute. We'll look and see if Thurston's doing anything else right now. Any of their other courtrooms. Ooh, yes, they are. No, that's the same guy. 2's not live. 3's live. 4's not live. It's just 3. I think
that we might not finish in time.
I apologize. I got held up in courtroom 4 for an emergency for another client. So after that I could breathe a little bit better after that was taken care of.
Yeah, we made it. We had a good clip.
And they're done. Yeah, they're done with that block. So they might be back on a little bit later. We'll keep an eye out for Thurston. Maybe pop over to Kansas, see if something's happening there. Kansas 13th Judicial. Kansas is not live. Nothing happening in Kansas. Judge Simmons is live.
But on the newer ledger, it only shows payment without being stated how it was paid.
Okay, so I'm looking at a ledger. This goes back until August of 2024. You said that you were to be credited $1,100 in February of 2025. I see where there was a welcome card payment for $11.29, a credit there. That was on February 28, 2025. At the time, that it looks like brought your balance down to $634. Now we have the month of March of 2025.
Someone's
You're
behind
alleging that you paid your rent?
It's this guy.
Is that a yes?
Yes, ma'am.
That's his prison escape hoodie.
And April as well, but on the
Where's your evidence that you paid it?
Well, on the app, it only goes back 10 months. So I can't show
On
it.
what app?
On the rent app application they use. I tried to bring it up, but I couldn't get it.
Commonly, Americans can go into our bank accounts, so this is where it came out of my bank account. You don't have any of that evidence?
No.
Okay, so without evidence to prove that you paid it, I only can rely on the evidence they're providing that you didn't pay it. So March, no payment of rent was recorded, nor was it addressed. April, it says a lease violation. What does welcome home payment card mean? Is that like how he's paying the rent?
That was an app, yeah.
Oh, okay, got it. So it looks like I do see a $900 payment though, and that's March 2025.
That's cool.
I do see a payment in March of 2025. It was on the 27th though.
Hey.
At the end of the month. And then April, there was a payment credited on April 25th of $900. So they did credit you for payments for those months.
Right, so I don't see when I got to May, where the $1,900 come from. That's what I'm talking about. Like, where'd that come from?
Well, you already had a balance of $689.
I shouldn't have had a balance of $689 because with that $1,100, I should have been at zero.
Says who?
Says the judge from my paperwork right here. They said pay that and you should be at zero.
The order says pay $11.29 and the balance is zero.
Yes, that's what it was all one quantity to pay that $1,100 and then it will all go away. It was supposed to all be gone. So I don't know where the $689 will be coming from.
Where's this order that you're talking about?
I'm in the car. I thought I brought it all up here again, but I had it earlier.
There was a judgment earlier, it said 1129.
Yeah, that's the one.
And that's all I saw.
And that would have been zero.
And that was in February.
Yeah.
So why did he still have a balance after he paid that? Of $634.
Yeah, I can't explain that, Judge. You have to give us.
You're willing to waive the $634?
Yeah.
Okay, so that's gone. They'll take it off. Okay, so
He was right.
So that would have brought you, that would have brought you back to zero. So what it looks like is there was, after that, March 1st, $55 for utilities plus rent of $799. It says there's a utility rebate. Oh wait, no, it says an event, $64.76. Something electrical maybe, I don't know what that is. Mr. Bach, you see what that event is on March 5th?
I see that on the ledger, Judge.
And then there's attorney's fees that you were charged for them having to take you to court.
I proceed on why I had to pay their attorney fees when I was given a sum of $1,100. It didn't say I had to pay their attorney fees though. The judge never said I had to pay their attorney fees.
This guy's winning.
I can't explain 6476.
So we're gonna waive
Previous landlord, previous owner.
Got it.
My current owner's here, he doesn't even know.
Yeah, I'm gonna get rid of these attorney fees too, from 264.14. We're scratching that. Let's move on.
That was likely included in the previous judgment.
It should have been, but it's not on it as it relates to.
Understood.
Got it. So you still have rent though, $7.99 plus $55, which is $8.54. And it looks like you did not pay that before a late fee was imposed. So now you owe $9.04 is what it looks like it should have been. You made a payment though of $900, not $904. So that means you're carrying over a balance, of course. I'm trying to see if there's anything else that was imposed that we need to waive, because realistically, all you need to do is subtract the 64.76, the 264.14, and then the 634.36 from whatever they're saying you owe at the end so far, versus doing what we're doing now. There was, I think the late fee was appropriate in March. Let's see, April, you made a payment, but you didn't make the payment until the end of the month, so you get a $50 late fee. I don't know what the lease violation is for. Of $50.
Maybe that's the late fee?
Well, that's in May.
I don't know. I didn't do anything to violate it.
It says lease violation charge from April 30th, April 3rd to April 30th.
I don't know what that is. I didn't do anything wrong.
No clue. From the previous landlord, probably? Okay, well, we're gonna waive it because we don't even know what it is. We see your utilities and your rent for May was put there in a late fee because you paid it late, I assume. Let's see. All right, this ledger doesn't show when it was paid. It might show me on this one. Yes, looks like you paid the rent. If you paid one.
All these fees are getting.
You made only a $300 payment in May. You didn't pay the full amount. You recognize that. That's on the previous ledger that we had earlier.
Yes.
It said you paid on May 8th, $300. So you didn't pay the full amount of rent in May. I don't even think they assessed you a late fee though. Because that's what you took over, okay. So they didn't assess you a late fee in May.
Always got a $500 money order and a $300 money order. That's why.
Where do you see that?
No, that's what I usually always get when I go get a money order, $500 one and $300.
Sometimes something was going on in May of 2025 and you only paid $300. They assessed a $300 security deposit. I said that I was striking that because you don't even live in the house. And so if you execute a new lease and they want to do that, that's fine. But we're going to move that for now. Monthly rent for June, still $7.99 plus your utilities is $55. By June 6th, rent had not been paid. And so they imposed $50 late fee, which was appropriate. There was a payment made by you on the 13th of $450. Then there was another payment made by you a week later on the 20th of $429.26. And so that would not have cleared the complete balance, but nonetheless, $7.99 for July, plus your utilities of $55. There's a late fee on the 6th of July. It looks like on the 11th of July, you paid $454, and then you paid $250 on the 25th of July. So again, not the full amount. Then we go to August, $7.99 plus $55. There's a late fee because you didn't pay before the 6th or the 5th. And so it looks like you paid $750 on the 19th of August and then $150 on the 29th. We're doing September. There's utilities and fee assessed and a late fee. No payment at all made in September. October, your rent was assessed plus utility. There's a late fee. You did on the 31st of the month pay $500. And then rent for November, it looks like that's when there was an increase to $1,000. That was assessed. Late fees on the 6th was assessed. You paid $500 on the 7th. You have
That's a lot of late fees.
$387 electricity bill.
Ouch.
Versus the normal utility. What prompted that change?
He did not pay the electricity bill. We paid that and to get the electricity bill.
He didn't pay it? Okay, so they had to pay to keep your electricity on. Got it. So they charged you for that. You made another payment of $500 on the 14th. It says of November 2025. Your rent for December, $1,000. We see a payment of $500, a late fee of $50, another payment on the 18th of $500, and then we have January, $1,000, late fee, rent, no payment.
I'm sorry, ma'am. I made 3 payments a month. That's one of one of those was this, but
unless you get me proof.
Yeah, I know.
I don't have 3 payments.
Okay.
And so, yeah, you're gonna show me a money order, but that money order is consistent in time with this one payment here.
Those are online. Those are online transactions. Those 2.
What do you mean? You make them electronically from your bank account to theirs?
Yeah.
To their account? So you should be able to log in your bank account and show me where you have made 2 transactions from your bank account that came out and went to them. And then you have this receipt here, which would be reflective of 3rd payment.
Is he looking on his phone?
It's too much.
Take your time.
My car is too much job, so that's why.
Take your time. I have a little math over here I gotta do.
Little mouth.
Well, it looks like you're giving 1,013 off. Trying to keep notes.
Late fees go to the landlord. Judge is doing the math. Don't think the defendant's going to find those transactions, those bank-to-bank transactions. I don't think he would be doing any money orders for payments if he could just do a bank-to-bank transaction.
Well, so far I have he owes $4,576.32. I don't know if you got it. I am not imposing the security deposit on him.
Oh, the 3?
Yeah. I said if the landlord executes a new lease, then they can deal with that.
Yeah, pay the security deposit to the previous landlord that has been carried over to this lease.
The security deposit told him that, I mean, he was supposed to pay one?
Yeah.
That's why we went to court, because I paid it.
Well, I thought that's what the 1129 was for.
That's what it was about. Because they like.
Well, if the 1129 is for that, it can't be applied to your rent too. It can't be a security deposit and rent.
No, I had already paid it. It took me to court before because that was just a judgment they gave me. Just pay $1,100. Just give them $100. I was like, okay. I guess it was just whatever rent from that month, and then the security deposit and first month's rent. I'm like, I already paid that stuff. But she was like, well, just pay this month, and then they'll wipe that out. That's what they told me. So yeah, that's what happened. So it was already paid. They didn't make me pay that again. He just told me pay what I was due then. The $1,100 something.
This go through. This was an eviction in this court?
Yeah.
Okay.
Yeah, it was a year ago. It was in February. All I saw was the judgment that he brought. He showed 1129. I guess it sounds like he's claiming the 300 was part of that judgment. Either way.
Previous eviction.
Either way.
I'll tell you what the judgment was for. Because it can't be that you had to pay the 1129 so that it could go to the security deposit.
No, that's what it was.
Okay.
It was
for past due rent and security deposit?
Well, they lost the first month security deposit. That wasn't my fault. I'm
not asking whose fault was what, but why did you have to pay 1129?
Because they said I didn't pay my security deposit and first month rent.
So you were paying that towards the first month in security deposit then, is what you're telling me?
No, by the time we went to court, I didn't pay that month. So that's what the judge made me pay is that month. She threw that other stuff out.
But your rent is more than 11. What was not 1129
well,
at the time?
I had fees. I had like $200 and something for some
attorney
type of fee.
fees.
Something like, for me, yeah, and something else, like $100 doing something else.
File cabinet.
Because it was like the judge said, like he didn't move in for free, but I didn't get a free key.
This is not my specialty here. No one-piece file cabinets. The Lord help us. Okay, where do I go? Click the. I can't even think. It's small, right? Court filing, maybe. Filing review case. No. This one. Yes. Type in his case number.
I'm here. I'm just trying not to cover up the defendant.
I got the case number right here.
Oh. 25-04316.
I'll head north for the season.
Dash LT.
Helps me down the road.
We should have it in there. Dismissal by John.
They basically have to go back all the way through this file and
This was like right before this.
refigure out what the deal was. The landlord sold the property with this guy as an active tenant.
There's another one.
Now I can see possibly why.
This was before us. I don't know if this one's right. And this one had a judgment. That was on February 26th. So it's another one. Okay. Yeah, well, so this is from October.
Then they took me to court for that again.
How do I go back? Let's see. You should be able to see it. So it's 24-09133 LT.
I think that would be part of the 634 that we already took off. If that's correct.
This was before Judge Ward. Okay. Let's see. What is going on? Why is Mel coming back?
Part of this.
It wasn't part of anything. It was they took me to court
or
recharged me for something I already paid for. And she
They're all
said,
just
no,
talking to each other.
pay what you owe now because you paid.
Rent to retain possession, $115. Other money due $50, which is I'm sure a late fee, plus cost $264.14. Which was out here? Why were they charging you again?
Because I'm sorry,
that was rhetorical. I didn't actually mean for you to answer.
Okay.
264.14. She ordered all of that already, and that was the 1129. This was for rent to retain possession. Period. Past due rent. This what was ordered had nothing to do with what you're talking about.
We might go there.
Judges, even if that $300 would have been part of the 634, we already took out.
Let's check out the Hannah Payne.
The balance that they showed after the 1129. Awesome.
Okay, so everything in the file reflects that that was for a past due rent, sir, not for your security deposit. That allegedly was never paid. So, we've already subtracted, what did I subtract? I subtracted the 634, which would have been the balance that you're saying includes a security deposit?
I don't get confused. I was at 1013. If you add another 3, that would be at 1326.
I get all that, but what I went through what was assessed that shouldn't have been assessed and subtracted it from the balance.
Yeah, that's the amounts that I highlighted that should have been taken out. And $300. If you add the 300 more, that puts us at 1313.
They've got so much math going on. All right.
Either way.
Did you find anything else about the $500 or the belief that you had 3 $500 payments?
Do my job app, so it's very difficult to get into. I gotta get a company code.
Okay, I have that you owe $4,576.32. That's the judgment of the court. You need to pay that in 10 days or vacate the property. Any additional matters for the record?
Only that you say that number one more time.
Yes, no problem. 4,000. I wrote it down. $576.32. I don't think you want these copies. I've written all over them.
Yeah, we don't want those back, Judge. All right. That's what he owes. We're going to bail on that for just a minute. Let's do this Hannah Payne thing. If you guys have been following the story, we followed the case of Hannah Payne. And it was interesting to say the least. A very interesting case out of Georgia. Oops, that's the wrong one. I need this one over here. There we go.
Lenise Dawkins, Connor Liv Estes, Harrison Feinstein, Laverius Glass, Shanae Hall, Christine Hardy, Stephen Hodges, Joseph Johns, David Kahn, Nikia Malik, Taylor
There's Hannah
Martin,
in green.
Gabriel McCarthy,
Think.
Serena Noel,
Maybe
Justine
not.
Rainford, Mary Richardson, Sarah Rosenhoover, William Salisbury, George Shepard.
This is something
Sarah
else.
Stitkin,
Hold,
Andrew
please.
Tyner,
This is admission.
Kendall.
That's not Hannah in green. Sorry, these are people getting sworn in or made citizens or something like that.
During today's session, the court will hear argument in 3 cases. Presiding Justice Warren, as you can see, is not able to join us today due to a medical procedure. She will review the recorded arguments and will fully participate in the 2 cases in which she is not recused. She, I, and Justice Pinson are recused in the final case, and we will either take a break in between the 2nd and 3rd case, or Justice Pinson and I will simply step away. Justice Bethel will preside in that final case. The clocks are on the clerk's desk to the left and the right of the podium. Council will have 2 minutes of uninterrupted opening time to present key points.
2 minutes.
A green light will signal the end of the 2-minute opening and the beginning of the question period. Council may invite questions at any time. Any rebuttal time reserved in advance by the appellant will be deducted from the total time allotted from the main argument, and any time remaining from the main argument by appellant that is not used will be added to the reserved rebuttal time.
Okay, so there are the rules.
Counsel are not required to use all their time, as concise and focused arguments are often the most effective. And with that, Madam Clerk, please call the first case.
Yes, Your Honor. S26A0459, Hannah Renee Payne versus Estate, Andrew Fleischman for appellant, Deborah Leslie for appellee.
Okay, this is an ineffective assistance of counsel appeal. Hannah got like, I don't know, was like life plus 13 years with the possibility of parole, I think was her sentence for witnessing a hit and run. The hit and run offender drove off. She followed against the advice of the 911 operator.
May it please the court, my name is Andrew Fleischman. I'm here on behalf of Hannah Payne.
And shooting
please ask me questions at any time. Issue today is pretty straightforward. The lawyer in this case made two serious legal mistakes. He thought that neither citizen's arrest nor defense of others were available for legally incorrect reasons. Citizen's arrest because he thought it had been appealed, and that appeal was retroactive, and defense of others because he thought you could not act in defense of others if they were not someone you knew. The state does not dispute that he was mistaken about this. And under Hinton v. Alabama, the failure to research the basic point of law is almost, but not quite, deficient performance de facto. And this was not a minor error. Because the jury was not instructed on defense of others or citizen's arrest, even if they believed Hannah Payne's account that she stopped an impaired driver only with the intent that he wait for police or to protect others, even if they believed that he attacked her after she approached his car, and even if they believed that he was trying to kill her, under the instructions as given, the jury could not acquit. And in fact, the state told the jury exactly this. The state told the jury, once she poked the bear, he was allowed to defend himself. And it said she had no right, no powers to stop him. He had no obligation to listen to her. And that once she approached, he was allowed to defend himself however he wanted. In other words, trial counsel's failure to understand the law dictated the result of this trial, regardless of the facts. And that is why this was ineffective assistance of counsel. I want to talk about the strategy counsel did choose, right? In this case, he decided on false imprisonment, that his defense is going to be that no false imprisonment occurred. And he chose that strategy precisely because other avenues based on his legal mistake were unavailable. He believed, probably wrongly, that if the victim of a false imprisonment can potentially escape, that means the crime has not occurred. And of course, that's not true. As we know from the cases cited in my brief, when someone is falsely imprisoned, if you are locked in a basement, for instance, the fact that you could shimmy out a window does not mean that the person is innocent of the crime. Here, trial counsel argued that because potentially Mr. Herring could have driven around up on the curb in order to get away from Ms. Payne after she stopped in front of his car,
Just 2 minutes.
that meant no false imprisonment occurred. But that's not the law. And it was also contradicted by so many things in the record. First off, we have Hannah Payne's call to 911. So she talked to the 911 dispatch operator who tells her, don't chase, be safe. She says, I'm just going to stop in front of him. I want to stop him from causing another accident.
Counsel, let me interrupt you and just ask you a fundamental question at the outset. Is it your position that the citizen's arrest statute that was in effect at the time permitted Ms. Payne to follow the victim from the scene of this accident and detain him, confront him?
Yes.
And if so, how do you get to that result based on the wording of the statute that allows, at the time, somebody to prevent the escape of a fleeing felon and not someone who's fleeing from a misdemeanor?
Well, first off, you're under Pinckney v. State, a court of appeals case cited in my brief. The court of appeals held that a police officer whose post-certification had lapsed could, as a private citizen, perform a stop of someone else, a traffic stop, even if the offense was only a misdemeanor. Second, here, this Mr. Herring did commit crimes that indeed could be considered felonies.
But
not just that he disregarded.
Does that case allow someone to, after making the stop, to then engage with the person the way Ms. Payne did?
Well, Your Honor, the record is conflicted on how Ms. Payne engaged with him. It's possible that what it allowed was for the police officer to stop somebody using his lights, pull them over, and then talk to them. I don't know if it went further than that. Really, all that reasonableness questioning is up to the jury. Could they determine that what she did was reasonable? And while there were some witnesses who said that Ms. Payne approached aggressively and knocked on the window with her cell phone, Ms. Payne's own testimony was that she had her cell phone out and she said, hey, police are on the way, I need you to step out of the car. And there are good reasons she would want Mr. Herring to step out of the car. After all, he had just blown through a red light, collided with a semi-trailer, disregarded police commands, floored it into traffic, right? She had witnessed all of those things. So her reasonable concern at that point is that if he stays in the car, he might hit her or he might continue to flee and hurt other people. There was a real risk to the public that she was avoiding, more heightened than in your typical citizen's arrest case where someone is stopping like a shoplifter. And for that reason, I think the statute—
How long were they stopped at the scene of the accident before this chase ensued?
20 minutes, Your Honor.
Your position is that under Pinckney, a citizen has the right to chase a defendant or a victim who's leaving the scene of an accident.
Your
for
Honor?
a mile, 2 miles, how many ever miles it takes, and block them in, detain them, and confront them in their car.
Yes, Your Honor, that's my take. And I think, in fact, just in our daily life, when we
How does that square with the wording of the statute that says if the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion? Why does the statute refer to a felony if you can do this for
Supreme Court
somebody who's
questions.
committed a misdemeanor?
Because I believe the statute also says a misdemeanor committed in their presence, Your Honor.
I'm talking about the language of the statute that refers to somebody escaping or attempting to escape.
Well,
which is theoretically what this victim was trying to do.
Well, first off, if somebody floors into traffic impaired in a disabled vehicle, they have already arguably committed aggravated assault, right? If you strike somebody with a car, you cause an apprehension, a reasonable apprehension.
If you
of harm.
cause a traffic accident?
Yes, Your Honor.
That's an aggravated assault?
And
How is that the case?
Well, there's a case called Patterson. I see Justice Peterson smiling here. In 2016, a man, in a case called Patterson, a man struck somebody with his car. And the question was, is it aggravated assault if he didn't intend to strike them? And this court held that even if you did not intend to strike someone with a car, that's still aggravated assault because you cause the apprehension of harm. And for some reason, apprehension of harm does not require intent in Georgia.
So, if I were to leave this courthouse this afternoon and cause a fender bender and injure somebody, that's aggravated assault?
Yes, it's a result I very much disagree with. And Justice Blackwell wrote a great dissent about how crazy that is. He was joined by, I believe, Justice Namias and maybe Justice Peterson.
I was not on the court yet, but I would have joined it had I been on.
Yes, so let's take that out of the equation because.
Well, you might think that's crazy,
that
but
is the controlling law today.
So I want to come back to the nature of your claim, which is an ineffective assistance claim. And you referenced that this attorney was simply unaware of the status of the law. And while that's, important, it's not really controlling for ineffective assistance. We have to say that no reasonable attorney would have done what this attorney did. Isn't that a better, when we say deficient performance, it doesn't really matter why this attorney acted this way. The real question is, could this be a reasonable thing for an attorney to do?
I'm going to disagree with that. So under Hinton v. Alabama, if you are failing to research a basic defense in your case, then the Supreme Court of the Supreme Court of the United States said that's basically deficient, even if another lawyer might have made the same choice with sufficient research.
So if you fail to research something and it turns out to be inapplicable, no one would ever know it was deficient, right?
That's correct.
So my question is, in light of the questioning from Justice Land and in light of this issue of, what did the old statute mean, explain to me why a reasonable attorney might say, I don't really want to litigate the question of whether this was a felony, I don't want to litigate that. And so I'm not going to turn to it. And in some ways, I kind of want to prompt that into a conversation around why, is it one or the other or both? The defense of others component, which do you feel like is the larger departure from the standard from your perspective?
Well, so what you said on Floyd and other cases is at the point where you've established that the attorney has made a mistake of law, then you have to show that it's not part of a sound strategy. And here's why I don't think it was a sound strategy in this case. Hannah Payne told 911, so his defense that no false imprisonment occurred, she told 911 that she was stopping him, and that was her intent. The witnesses all seemed to agree on it. Traffic was heavy, and the defense attorney chose was that he would have to drive up over the curb to get away, which the state points out to the jury, he's got no duty to do that. He's still falsely in prison, even if he's got sort of a crazy escape route. So it's sort of like Swanson. The defense that he chose is basically inapplicable in the same way that in Swanson a felon couldn't claim self-defense. And he only was stuck with this avenue. That's not a very sound strategy because he did not know that he could raise defense of others.
Was the issue of false imprisonment a jury question?
Yes, Your Honor.
And the jury could have acquitted Ms. Payne of false imprisonment.
The jury could have, for whatever reason, acquitted her of false imprisonment. They always have that option. But was it a
This
sound?
lawyer could have pursued a defense strategy seeking an acquittal on a basis other than citizen's arrest, which is what he did, correct?
Absolutely. But the reason he chose this strategy rather than another strategy is because he failed to conduct research on a basic point of law, which is deficient performance. So in Strickland, we talk about how we give a presumption of regularity, a presumption that the lawyer is doing his job. When a lawyer fails to investigate, we diminish that presumption. The total failure to investigate results in a much diminished presumption that the lawyer had a good reason for what he was doing.
So let's presume deficiency. Why was there prejudice given all of the, I mean, there's considerable conflicting testimony in this case about what exactly it was that she did. And the jury was not required to credit her version. And a number of the other versions, I think you have a much harder time with prejudice. So why would there be prejudice here if there was deficient performance?
Because I think even the versions of events that are supposed to be more state-friendly actually still provide a self-defense avenue for Hannah Payne at the point where she's being pulled into the car and the car is accelerating. I mean, so Ms. Payne's account is that she approaches the car, she's being dragged. She says, I have a gun. She pulls it. They struggle over the gun goes off. Well, then you have Cameron Williams. Cameron Williams says, well, she's up on her tippy toes. They're struggling back and forth. You have Miss McCraney. There's some sort of struggle. You have Miss Rowland, who says, well, Hannah was trying to unlock the door for a minute or two inside. Now, I don't credit her view of what happened, but what's clear is that Hannah is being pulled into the car. The car accelerates and strikes her car while she's being pulled into it. And this court has held that being dragged from a moving car is enough to pose a deadly threat. You can respond with deadly force. So,
But the video from the bystander doesn't show that, right? I mean, we have the video and it's pretty clear. I mean, she's struggling with him perhaps, and then she steps back and shoots into the car and kills him.
So I think that's how the state characterized it, but if you view that video carefully, what you'll see is the shot goes off. Once the shot is fired, she is released and she falls backwards. So to the extent that the state argues the video shows that version of events, I think it's simply mistaken, Your Honor. What happened here is that this man...
Tell me how the defense of others approach, tell me what counts you think the defense of others would have applied to. All of them?
No, Your Honor. I think the defense of others really applies to the initial false imprisonment only. So trial counsel admits that can't be defense of self, which is the only justification claim he raised. But stopping an impaired driver, and even the initial officer thinks he's impaired, from driving on the roadway is this textbook example of defense of others. Now that might mean, like the officer at the scene, you wish you had taken his car keys. It might mean that if your spouse gets really drunk, you don't move your car out of the garage so they can't get out. But that is a classic defense of others. And we would not say that taking a drunk driver's car keys at a bar is unlawful false imprisonment, because you are justified by that defense of others.
I like his arguments.
I have some time left. If there's no questions, I'm going to sit down.
Very good.
Thank y'all.
That was amazing. That was amazing. Okay, state gets up now. Let's hear their side of this. Buckle up. Here's where it goes off the rails. She gets 2 minutes. 2 minutes before they get.
Good morning, Chief Justice, Justices of the Supreme Court. My name is Deborah Leslie, and I represent the state. May it please the court, a defendant is entitled to a defense instruction only when there is some evidence supporting each statutory element. That threshold was not met here. The evidence showed that Ms. Payne was the aggressor. She used unreasonable force and fatally shot an unarmed, non-threatening motorist, Mr. Herring, after ignoring 911 directives. The trial court correctly denied the motion for new trial because the evidence did not authorize either a citizen's arrest or defense of others instructions. Because the instructions were not supported by the evidence, trial counsel was not deficient, and there is no Strickland prejudice. If I may proceed, if there are no questions. Thank you. I'd like to start where Ms. Payne approaches the vehicle where my esteemed colleague characterizes that she was making a legal stop. If I may, Your Honors. Your Honors, these are States Exhibit 21 and 22. If the court would, the picture reflects, if the court shows that this is Mr. Herring's truck. This is Ms. Payne approaching the truck. In her right hand is a gun. This picture is right after, this is the steel frame that was also showed at the court to the jury, along with the video, which is States Exhibit 20, where Ms. Payne fatally shot Mr. Herring. This was captured by the video, the cell video that was taken, and that would have been States Exhibit 20.
She doesn't have the
This
polish
picture
of the
right here
defense attorney.
Right before the shot, the shooting, where there seems to be maybe her giving him instructions. You can hear it on the video. I'd invite the court to, if you haven't already reviewed it, at least 2 or 3 times, if you would please review it again. We'd appreciate that. Where she is commanding Mr. Herring to get out the vehicle. Right there at the left, it's a little difficult to see, but that is Ms. Payne's vehicle, where it has blocked Mr. Herring's vehicle. He cannot move in. And the car window right here, that is Mr. Cameron Williams' vehicle as he is riding by and filming the incident.
Look at the body language of the justices.
As the court can see, this is not a lawful detention. This is unreasonable force.
Counsel, so is it the state's argument that there wasn't even slight evidence to support a citizen's arrest instruction?
Your Honor, slight evidence is sufficient only when there is some evidence supporting each statutory element of the defense. Here, there was no evidence of that to support citizen's arrest.
So what was missing? In terms, I mean, slight evidence is just a little bit.
Sliver.
So what are you saying is missing such that it's not even an instruction that, if requested, should have been given?
The lawful detention, an imminent threat of defense. Here,
But so, I mean, your colleague on the other side points out that there was a lot of conflicting evidence about the circumstances as a whole. I mean, if you look to everything sort of the state credits, then sure. But given the balance of that evidence, if the jury could have credited a different version of events, isn't that enough to warrant the instruction?
even so, Your Honor, still the evidence must support the statutory element of the defenses of citizens' arrests and defense of others, and none was here.
Which element was lacking?
For citizens' arrest, a lawful detention, defense of others, there was no imminent threat of unlawful force against a third person.
I mean, she testified that there was, didn't she?
Yeah.
No, Your Honor.
When she's chasing him, I mean, she says he's careening, across the road. That's not imminent threat to others?
Your Honor, that was Ms. Payne's subjective belief. There was no...
But that's evidence.
Yes, Your Honor.
Why isn't that slight evidence to support the giving of the charge?
There was not a lawful detention, Your Honor.
What about the detention? I'm not talking about the interaction when we get to the car itself. What about the detention was unlawful?
Your Honor, before we get to that part, Ms. Payne was instructed by 911 not to pursue. They had the tag number.
Is, under the old code, I mean, I know it's all been repealed, under the old code.
Yes.
A citizen, what about the old code allowed 911 to take away a citizen's arrest rights under the old code?
This was not a felony. This was a misdemeanor.
Did she have the right to chase somebody that had just committed a misdemeanor?
I'm sorry, Your
Does
Honor.
a citizen have the right under this statute to chase somebody who has committed a misdemeanor?
No, Your Honor.
That's not in the statute, is it?
No, Your Honor. It has the former OCGA statute that was in effect at the time did not permit you to chase an individual that had committed a misdemeanor. It was a felony, a hit and run.
Is that consistent with the Court of Appeals ruling?
No.
Then?
My understanding is, Mr. Fleischman has cited a case to us from the Court of Appeals saying that that actually does extend to misdemeanors.
Pinckney.
Pinckney.
Hinton v. Alabama.
Pinckney.
Pinky.
That's where he said that someone could be charged with aggravated assault just for a traffic accident.
I'm not aware of Pinky's holding, Your Honor, but I would be glad to provide the court with a supplement if permitted.
So again, in a world where we're talking about slight evidence, I mean, if there's an accident with potential injuries, we don't know what she observed. She saw the condition, and we see somebody leave. That might be sort of fleeing the scene of an accident. And then you see somebody driving in an erratic manner. I mean, I'm just trying to I want to make sure that I understand the state's argument in terms of why there wasn't slight evidence. Now, just because there's slight evidence and just because a charge may have been allowable if asked for, doesn't make it ineffective assistance of counsel not to ask for it. I just want to make sure that I understand the state's argument as to why the charge was unavailable as a matter of law.
Okay, pause for a second. Let me tell you why what she just said was so bad. I'm not aware of Pinckney's holding. She wrote the response to the defense filing. The defense filing included Pinckney, right? How is she not aware of that? Did she not read it? I'm sorry.
Your Honor, the charge was unavailable as a matter of law because the law does not permit a citizen to chase, block, strike, and fatally shoot an unarmed, non-aggressive motorist, Mr. Herring.
So, counsel, let's assume that there was at least slight evidence to support the instruction. I mean, the state doesn't need to win on that point to prevail here, right? The question is just, it's ineffective assistance. So the question is just, was counsel's performance deficient here for not requesting this instruction at all, given the sort of other defenses and things like that? Can you move to that part of the argument and explain why a reasonably competent attorney might not have requested this instruction and instead sort of conducted this trial in the way that trial counsel did here?
Yes, Your Honor. Mr. Tucker testified that considering the evidence that Ms. Payne had approached the vehicle and that there was a fatal shooting, the theory was self-defense and accident. And if pursued citizen's arrest, that would have, what he testified to, conceded false imprisonment. And he knew that if he opened that door, there would be extensive cross-examination regarding her false imprisonment.
And so what's your response to your colleague's argument on the other side that false imprisonment here was going to be pretty hard to disprove because even a brief sort of stop or restraint can amount to false imprisonment? In other words, that defense was a quite weak defense such that it wouldn't have made sense to prioritize that one over citizen's arrest?
Your Honor, in regards to Mr. Tucker's testimony at the motion for new trial, Mr. Tucker looked at the evidence which did not support a citizen's arrest or a defense of others because of the things that happened that led up to the fatal shooting. Based upon the evidence, it did not support the statutory
She's saying
elements
the same thing over and over
of the omitted defenses.
So on that point, the same conversation we had about the citizen's arrest piece, as I understand the argument from your colleague across the way, the defense of others really applies to, potentially applies to the false imprisonment count. What element of defense of others would be missing with respect to the false imprisonment count? I mean, in other words, was there a lack of evidence that this defendant, not contested evidence, just no evidence whatsoever, that this defendant blocked in the car, understanding that to be an act of ceasing an impaired driver from continuing on the roadway? And what else what other evidence would have been required to get a charge on defense of others?
The imminent threat, unlawful threat of force against a third party. That would be the element that's missing.
Okay, so if a citizen, again, this is not the citizen's arrest part. If a citizen sees someone who is, blatantly intoxicated and pulls their car in behind their car, they're, leaving a restaurant, getting in the driver's, start turning their car, pulls it in behind, and they say, the reason I blocked their car in, and they're charged with false imprisonment, the reason I blocked their car in was to keep them from driving out on the road and killing themselves or someone else. They would not be entitled to a defense of others charge?
Respectfully, given those circumstances, those factual, maybe so, Your Honor, but here, there was the statutory element here that is missing is the threat, the imminent threat of unlawful force against another. That was not present here.
Well, but the imminent, go ahead.
How far away was the stop from the traffic accident? Do you know?
Your Honor, respectfully, I do not have.
Because didn't Ms. Payne, the argument on appeal is she's just trying to stop this motorist to protect other people to get her off the road, but didn't she testify that her intent was to get her to get the victim here to turn around and return to the scene? In other words, drive the vehicle back to the scene, not just stop and let's get the police to come here. But her testimony was, I was trying to get him to return to the scene of the accident, which seems inconsistent with an argument that I'm just trying to.
He's throwing her softballs.
Yes, Your Honor, that is correct. It is inconsistent at the point where, to begin with, the point where she left the initial accident scene where Mr. Herring had a medical emergency, hit the back of the semi-tractor trailer. The Department of Correction officer that was on scene at that time, off duty, noticed, based on his experience, that Mr. Herring at the time was confused, slumped over the seat. He appeared to be having some type of medical episode based on his observation. At that point, he got out the car. He told him, just stay there. I've called 911. Help is on the way. That's what he told everybody on the scene. And then Mr. Herring got out the car, looked around, confused, got back in, and left the scene of the accident.
20 minutes later.
I'm sorry, Your Honor.
20 minutes later. 20
minutes later, before we leave that scene, he asked them, He didn't ask anybody, he just told them, get the picture of the tag, get the tag. And that's when Miss Payne was getting the picture of the tag or got the tag, called it in, and 911 dispatch told her, we have the tag, thank you. So from that point, it exceeded a citizen's arrest because they instructed her not to follow. Do not chase.
Can I ask you a question? Say if we say it was deficient, was it prejudicial? Did it prejudice her? And if not, why not?
Your Honor, assuming that it was deficient, still there is no Strickland prejudice because there is no reasonable probability of a different outcome considering the evidence.
Wow.
Counsel, I guess I'm unsure about the prejudice piece, because if we assume deficiency, it's because any reasonable counsel would have requested this particular instruction and thus sort of advanced this particular defense, even given the other defenses that were available. So if we assume that and then get to prejudice, it seems like it becomes a lot harder to say there's not a reasonable probability of a different outcome, because the whole basis for saying it's deficient is like any reasonable attorney would have raised this defense despite these other defenses being available. In other words, implicitly, those other defenses would be pretty weak, right? And so I just have trouble squaring prejudice with, if we find it deficient, how we don't also get to prejudice when that's the kind of argument that's being made for deficiency. Can you help me out with that?
Yes, Your Honor. Considering the evidence, Ms. Payne chased, she blocked, she struck,
she has the same
and she
talking
fatally
points.
shot an unarmed motorist, Mr. Herring.
She's saying the same thing
Her
over and
conduct
over.
escalated past what a reasonable citizen, if we should say, would do. Here, the evidence did not support citizen's arrest or defense of others instruction. And because it did not, counsel wouldn't have been deficient for pursuing meritless instructions. And the court does not presume prejudice based on omitted instructions that are not supported by the evidence.
It's not supported by the evidence, but there was evidence. She just
If there are
doesn't
no
believe
more
it.
questions?
So before you sit down,
Yes. Yes,
there's
sir.
one more thing I need to ask you about, unfortunately.
Buckle up. Here we go.
In reviewing the trial court's order denying the motion for new trial, there are at least 5 citations to cases that don't exist. And there's at least 5 more citations to cases that do not support the proposition for which they're cited, including 3 quotations that don't exist. My understanding is that you prepared the order for new trial, the denial order for the trial court. Were those citations in the version of the order that you submitted to the trial court?
No, Your Honor, I do not believe so. They were not. I did prepare an order. That order was revised.
So those non-existent cases were cited in your initial brief opposing the motion for new trial.
Liar, liar, pants on fire. It's not in your notes, ma'am. You're not going to find the answer there.
Your Honor, I'm not aware of that, but I would be glad to research that and provide the court with a supplement.
Let me check it into
We'll
ChatGPT.
get a briefing order out directing what you need to supplement with. Okay, thank you.
Thank you.
Mr. Fleischman, you have some rebuttal time left.
Not that it matters, but ever since I was a little girl, I always wanted to be a police officer. That's how the prosecutor began their closing argument. They're quoting Hannah. And on this day, she got her chance. Okay? So when the state says there's no evidence of citizen's arrest at all, they have to confront the fact that in closing, it was the first thing the prosecutor told the jury about. It was the most significant factor of this case because anybody looking at it, as the prosecutor would see that that was the central issue. And there was a lot of evidence to support it. I know we say the state says there's no prejudice, but Hannah Payne's account is that when she approached the car, she was grabbed in, she was dragged, she was punched, and she was scratched. And the physical evidence corroborates her account exactly. She had a black eye and scratches on her neck and a torn shirt. And none of that is consistent with an account in which Mr. Herring is not defending himself at all. And even this picture shown here, Mr. Williams took that picture. He took that video, but only after the altercation had been going for a while, when Ms. Payne was trying to get her hands free. So there is physical evidence that corroborates her account. And the state's witnesses were so at odds with each other and their previous statements that the prosecutor told the jury, well, this is not a memory contest. Why? Because so often the accounts the state gave were inconsistent with earlier police reports. For instance, Ms. McCraney testified at trial that Ms. Payne only took the gun out after the car started accelerating. Her count in the police report was totally different. The account of Officer Robinson on the day of the incident was that this driver was impaired. At trial, he said maybe he was having a diabetic episode. So we can sort of see how these accounts change and why a jury might credit Ms. Payne's account over the accounts of some of the other witnesses, especially since so many witnesses corroborated the central came. There was a struggle in the car and she was trying to get away. So that is your prejudice. I want to briefly address the citations issue. I'm sorry I didn't catch it. I sometimes don't read all the cases cited in my opponent's brief, and this is an instance where I didn't do that. I regret that I did not bring this to the court's attention. I am sorry about it. This is a case where trial counsel really didn't research the law, didn't think about it.
And Mr. Fleischman, can I ask about that point, and particularly Hinton, which you're obviously right to cite. It has really good language for you that says an attorney's ignorance of a point of law fundamental to his case, combined with failure to perform research, is quintessential unreasonable performance. But then we have cases, Floyd and some other cases, that say, well, counsel's decisions based on a misunderstanding of the applicable law are not per se deficient. The defendant essentially carries the burden by showing that it can be considered sound trial strategy, what sound means, and whether that's different from no reasonable attorney, I don't know. I guess my question is, are those decisions wrong or in conflict or in tension with Hinton, or is it only an objective analysis? Like, to what extent does the subjective wrongness of the attorney's decision carry the day for deficiency?
I do think those decisions are wrong. I think they are in conflict with Hinton. But if we want to bring them closer in line to Hinton, then sound strategy has to be something like a good strategy, a strategy a smart lawyer would have picked after looking carefully at the facts. And here, as I've discussed, saying that no false imprisonment occurred at all is not a sound strategy. It conflicts with what Ms. Payne told police, and it conflicts with every eyewitness. It conflicts with that picture. This truck couldn't move. And defense theory's idea that if you could take heroic measures to escape, it's not a false imprisonment, was just another example of how he failed to research the law in this case.
So I guess your view of our case, I mean, you say those are wrong, which they might be. I'm not sort of getting into that point. But in your view, to square it with Hinton, if trial counsel stumbles into a smart strategy, that's not deficient. But if they stumble into a not unreasonable strategy, it is, I guess.
Let's imagine the false imprisonment never occurred defense was really strong, really good. Like, I don't know, she detains him for half a second and he moves around and it goes on about his business. Well then, okay, the lawyer didn't think of citizen's arrest, but a smart lawyer might have very well picked the same strategy after thinking about it. The issue in this case is that the defense he chose was so much weaker than citizen's arrest or defense of others in explaining this conduct that it's not a sound strategy under Floyd and Swanson. It's a lot like Swanson, right? So in that case, the lawyer doesn't raise defensive habitation, which doesn't care if you're committing a felony, because he doesn't think of it, and instead goes with self-defense, which really can't work under the facts of the case if the jury finds that his client is a felon. And for that reason, y'all said not a sound strategy. I think that's what we look at here. So Ms. Payne is a credible witness. The state addresses her as a credible witness, says, oh, she came in here with her testimony all polished. That's not how to describe it. I think there is a sincere worry on their part the jury will believe her. And when the state says there's no evidence of citizen's arrest at all, how can they say that when they made it the first thing they addressed in closing? It's just hard to get past for me. I just don't think they really mean it. Ultimately, ineffective assistance of counsel claims are about whether we can have confidence in this verdict. The state told the jury repeatedly that even if they believed Hannah, they still had to convict. And I believe a jury very well might have believed her. They convicted anyway. Under the right law, they would not have. We cannot have confidence in this verdict, and I respectfully request a new trial.
Boom.
Thank you.
Thank you very much.
Wow. That's the
do our best to get a decision for y'all within the time required by law.
And order.
Madam Clerk, will you call the next case?
Okay, so that's all we're going to do with that one. The order that we read previously was the order that this court put out to the state saying, tell us why all these citations, all this ChatGPT slop was included in your motion. Tell us why. The only thing that would have made this better is if the defense attorney who was making the motion had caught this and brought it up first. He said, I tried to research their point of view, but it doesn't exist. That's the only thing that would have made that better. And it was such a strong argument. I realized this was a tough case, right? This was a case where in some aspects it did look like she had no business doing what she was doing, but strictly under the law, in others she did. And this is the case where I decided I can never stop in Georgia. So love this lawyer even took it to the Supreme Court clerks to find the hallucinations. I can't do Shonda Vander Ark's motion. Can't do that one. For reasons, Laura, sorry. It was a very good argument. I just love hearing them argue, right? First of all, there are two parts I love of this. A Supreme Court bench of judges firing off some of the smartest questions any legal mind has ever come up with after thoroughly analyzing the case, watching the videos, reading the briefs, reading through transcripts, whatever they did after thoroughly educating themselves on the case and then coming up with the really nuts and bolts. This is the question that applies. I love hearing that. And it's rapid fire. Like you're mid-sentence saying, Your Honor, I think that you should, what about? And they just interrupt. And you've got to be prepared to answer. And that level of preparation does not come by accident. And I would say the state didn't have it. The state had their talking points, and every time they were asked a question, they diverted back to the same talking points because the evidence didn't support that. It was terrible on the state side. Defense nailed it. Case law, on point, citing who this court has ruled this in the past. This is the current law. It was so good, all in 3 minutes. Thank you, Mathis, for that one. Wow. Love watching appeals courts, even though when I don't understand. It was good. I can't wait to hear the response. And honestly, maybe I'm not sure if anybody else is doing this. Can't we do some FOIA requests? This can't be the first briefing this woman has written and filed, right? If we did some FOIA requests, could we find other briefings that this state's attorney has drafted? Maybe close in time to this one? And see if there might be some other cases out there that are languishing under a pile of ChatGPT crap. I don't know. Let's all my smart people out there, compare her briefings from before and after she paid for premium ChatGPT. You probably don't even need FOIA. What's her name? I could go back. Give me just 1 second. Where are we at? It's this one. That's not it. It's this one. Okay.
To get out the vehicle. Right there at the
Hang on,
left.
find her very first moment she gets up.
Approach. Tell me what counts you think the defense of others would have applied to. All of them?
No, Your Honor. I think the defense of others really applies to the initial false imprisonment only. So trial counsel admits that can't be defense of self, which is the only justification claim he raised. But Stopping an
There's our
impaired
case
driver,
number.
and even the initial officer thinks he's impaired from driving on the roadway, is this textbook example of defense of others. Now, that might mean, like the officer at the scene, you wish you had taken his car keys. It might mean that if your spouse gets really drunk, you don't move your car out of the garage so they can't get out. But that is a classic defense of others. And we would not say that taking a drunk driver's car keys at a bar is unlawful false imprisonment, because you are justified by that defense of others.
He knew he knocked it out of the park, and that's why
Have
he's
some time
smiling
left.
here.
If there's no questions, I'm going to sit down.
Very good.
Thank you.
Very good. You answered all their questions and had leftover time. Oh, sorry. I talked over the name. 1 second.
Yeah.
Ms. Leslie?
Ms. Leslie. Ms. Leslie is all we got. Deborah Leslie. Boom.
Good morning, Chief Justice, Justices of the Supreme Court. My name is Deborah Leslie, and I represent the state.
Okay, that's as far as we need. That's all we needed, ma'am. Thank you for that. Deborah Leslie, future has it. All right. We might have to do some digging there. All right. Let's see. We're gonna you know me, I only want fair trials anyways. If Hannah didn't get a fair trial, then give her a new one. I still would vote guilty like I did before. Yeah, I'm with that. It's not that there's no part of this appeal that is saying that the jury got it wrong. They're saying that the lawyers and the judge got it wrong and then gave it to the jury to make a decision. The jury's decision is not what's being appealed. Although it could, the appeal being upheld could result in a different jury reaching a different decision. But crazy. Is Judge Simpson in session? Yes, he was just a minute ago. Let me see if he is still. Let's see. We've got Kansas. That's not it.
Is asking for.
Let me find.
Well, Your Honor, in his lengthy motion, I can't say that we have in our discovery everything, certification manuals, every page, et cetera. We feel like the discovery we have is all the discovery and is appropriate, but I can't say that we have every piece of discovery that he requests in his motion.
All right, anything further, Mr. Page? I'm sorry, Mr. Rumford.
I guess my only question would be is I requested in-person discovery as well. That would wipe out any necessary, I guess, reproduction costs, because I'd be able to take photographs and make my own copies. I was not aware of any rule, local or otherwise, which I even mentioned in my email, that there's a standing order or any statute in Kansas that allows charges for discovery. And I even asked if they could point me to that, which he pointed me back to the 223212 statute.
Right, Mr. Baca, do you wish to make a response to this complaint that he wanted to come in and make his own copies and was not allowed? Do you have any response to that?
I do not, Your Honor. I wasn't party to that request to know for sure if it happened. What I can say is, everything we do provide is electronic. I do believe that is our method, is providing that to him, but that doesn't negate the fee. For, as the court inquired, the cost and the time and expense, that's all still been prepared. Whether he reviews that in person or not, that all still had to be prepared, and we would still ask for that fee.
All right. Well, here's my ruling. Mr. Page, you are entitled to discovery, and filing the motion would be appropriate. But It is also appropriate and approved by law that you pay a reasonable fee for the production of documents. It takes time and money to order the beta disk. It takes time to transfer what you're asking, to look through the file for what you're asking for, to put it on the disk. Somebody has to physically go and do that. And even if you wanted to come in and go through their files, somebody has to come and prepare that information for you, to stand there away from their normal duties and present that and watch with you and make sure that it's protected and used appropriately. So that there is time involved from the county attorney's staff to produce this. And that is why case law does allow a reasonable fee to be charged for it. And I can tell you that it is customary, not only this office, but other prosecutor offices around the state and the country, that the reasonable fees are assessed for discovery. And that's whether you have an attorney or whether you represent yourself. $25 for the list of discovery you're asking seems quite reasonable. And so I find it was reasonable for them to ask that. It was lawful and appropriate for them to ask for it. And you chose not to pay the bill.
It's over $25.
You said you didn't know of any law that said you had to or that we should. Well, again, if you're going to represent yourself, you need to know the laws you're arguing, sir. And so I'm going to deny the request for continuance. You've had sufficient time to get this bill paid. I haven't heard you say you couldn't afford to pay it, that you were a pauper or that needed to be waived. And I'm not saying it.
Your Honor, I haven't had an opportunity to get to a post office or anywhere to get a money order. And by the time I would mail it to them, we'd be in this situation here.
This is my turn to make my decision now. And the fact that you didn't feel like you could get to a post office, I suspect that you were getting mail and that you could have mailed stuff if you wanted to. I don't find it credible that you just didn't pay this because you couldn't get to a post office. I just don't find that factually plausible or credible. And again, I'm just not buying your argument. I'm ordering that we proceed to trial at this point, as this was set February 18th at your request. That's over a month. And I also see there's a document in here from March 25th, which would be today. Maybe this isn't the one I'm thinking of. All right, strike that. The March 25th docket is for this case. So just a moment, please.
If I may, Your Honor.
Not yet.
Not your turn
First docket entry is December 1st to 25. Defendant wished to contest his ticket. So you've known since December 1st to 2025 that you wanted to trial, that you've had all this time to pay that bill, to request the discovery. So I don't see how it could be prejudicial to you that you're the one that chose not to pay or didn't find a way to get to the post office. We met February 4th to 26th, and that's when you said you wanted to take this to bench trial. So we set it for today for bench trial. Okay. Here's the note I was looking for. March 25th of 26, the defendant called this morning asking to talk to Judge Webster, and the clerk explained he couldn't just talk to the court outside of the courtroom. You said you wanted a continuance for this hearing because you never received your discovery. The clerk told you that they couldn't give you a continuance that was set for 1:30 today. You waited till the very day of to ask for a continuance. You said the only thing you got from the county attorney was an invoice. So the clerk said, well, if you want to talk to Judge Webster, if you want to address these, show up at your bench trial time today and do so. And so that is what you've done, which would be appropriate.
And now we're going to hear the case.
But at this time, as I said, I find that this delay is created by you because you didn't want to pay a reasonable fee of $25 for discovery. And I understand from prosecutor that beta disc would have covered pretty much everything you were asking for, even though you were asking for a lot of items on your motion for discovery. So at this time, we will proceed with trial. If the state has your first witness, are there any opening statements from either party?
It's going to cost you more than $25.
The state would waive opening statement, Your Honor.
Mr. Rumford, do you want to make a statement of what you think the evidence will show?
Your Honor, respectfully, for the record, I'd like to object to proceeding without having received the discovery. I know that we've gone over that to your satisfaction. I would also like to request that we narrow the scope of the evidence that is being submitted.
What? To stuff
to
that
what?
doesn't make me look bad.
Narrow it to
What I've been provided, which is a citation with a name and a badge number.
All right. I think that's reasonable.
Wow.
But if you don't want them to present certain things, I'm not going to let you. Well, we'll strike that. All right. So you don't want to make an opening statement of what the evidence will show, or do you?
I do not, Your Honor.
All right. Opening statements are waived. Mr. Baca, any objection to limiting this to the information on the citation? I know you usually get into the officer's training and experience, but the defendant doesn't want to get into that. So I'm not going to let anybody argue about that if we don't get into it.
Well, Your Honor, yeah, I guess what's hard to understand is what that might entail. I understand if we don't want to speak to the officer's training and experience, but we do at least plan to ask the officer everything contained on that citation, as well as some information about the LiDAR he used to obtain the speed of the vehicle.
All right, that's what the evidence will be limited to then. Go ahead, please.
Thank you, Your Honor. At this time, the state would call Sergeant White.
Sergeant White, please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Please proceed.
We could begin. Could you state your name for the record, sir?
My name is Thad White.
And Mr. White, where are you currently employed?
I'm currently employed as a sergeant with the Butler County Sheriff's Office.
Okay. And Mr. White, there was a citation issued on October 11th of 2025 by the Butler County Sheriff's Office. Do you recall issuing a citation in your current employment capacity?
Yes, sir.
Okay. And if we could begin, you were on duty in your current employment capacity on that day, October 11th of 2025?
That is correct.
Okay. And do you have any issues with recalling events from that day, October 11th in 2025?
No, sir. I remember the traffic stop.
Okay. And it appears that there's a citation on that day around the time of 22:13 hours. Do you recall your location on that day and time?
Yes, I was sitting facing westbound stationary just west of Tawakoni Road off Highway 54.
Okay.
My usual
And
spot.
on that day and time and at that location, what, if anything, did you observe?
I was doing traffic enforcement, checking vehicle speeds. I did stop Mr. Rumford for 87 miles an hour in a posted 65 zone.
Yeah,
So you indicated you did stop a vehicle around that time. Is that correct?
That is correct.
Do you recall what type of vehicle that was that you stopped?
It was a red GMC Sierra.
Okay. And so you're familiar with the boundaries of Butler County, is that correct?
That is correct.
Is this location you are conducting traffic enforcement, is that within the boundaries of Butler County?
Yes, it's rural Augusta, Butler County, Kansas.
Okay. And so on that day around that time, you observed a red Sierra pickup driving, is that correct?
That is correct.
And what did you first observe when you first saw this pickup driving?
The vehicle was traveling westbound. As it passed me, I checked its speed with my LiDAR, and the LiDAR registered a speed of 87 miles an hour.
And your LiDAR, can you just briefly describe what that is for the court?
It's a handheld laser. It uses a laser to detect the vehicles and speed. It measures distance. When you power it on, it does a self-check, lets you know that it passes and is operational. Further testing on it before using it, you pick a known marker and the distance from where you would be to that marker and make sure the range portion of the LiDAR is also working.
Okay. And did it do all these tests on that day as far as your recollection?
Yes, those tests are done before using the device in the field.
And did there appear to be any malfunctions with the LiDAR on that day that you recall?
There was no malfunctions. The instrument indicated that it had passed its test.
And have you received particular training or certifications using this LiDAR?
Yes, I'm a certified operator of the LiDAR.
Okay. And so what was the speed that you observed on the LiDAR for this GMC Sierra pickup?
87 miles an hour.
Okay. And once you made this observation on your LiDAR, what did you proceed to do at that point?
I initiated a traffic stop with the GMC Sierra a mile or two further west down the highway.
Okay. And did this vehicle pull over once you attempted to initiate the traffic stop?
Yes, it did.
Okay. Once the vehicle was stopped, what did you proceed to do after that?
I made contact with the driver at the driver's door, explained the reason for the stop, identified him as Mr. Rumford by his Kansas driver's license.
And his beard.
Mr. Rumford had explained to me he didn't realize he was going that fast and that he was attempting to get to a spouse or a girlfriend that was having vehicle trouble further down the road.
And do you see the person that was driving that vehicle on the Zoom call today?
Yes, I do.
If you could you describe what that person looks like for the court's record?
He
Sort of like a
has
gnome.
a lighter color T-shirt on. He has a beard. He's wearing
Britney Spears
a
headset.
mic on his right ear.
Your Honor, if I could have the record reflect that Sergeant White has identified the defendant as the driver of the vehicle.
The record shall so reflect.
And so once you had this conversation with the defendant about his speed, what did you do after that point?
I returned to my patrol vehicle, issued him a citation. He requested my business card at the end of the traffic stop. I also provided him with a business card.
Okay. You indicated the defendant indicated he did not know he was traveling at that speed?
He made a comment. I can't quote verbatim what was said, but something to the effect that he didn't realize he was going that fast.
Okay. Was there anything else about this particular investigation that you feel is relevant for the court to know today?
No, sir.
Have you ever had any other conversation with a defendant from that day in October to today?
No, sir.
Your Honor, I think that's all the questions I have for Sergeant White at this time.
Very well, thank you. Now, Mr. Rumford, you may ask questions of Sergeant White. It's not your time to testify or to tell your side of the situation, but you can certainly ask Mr. Rumford questions about his testimony or the stop if you wish.
Yes. I'm sorry, could you repeat your last name for me?
It is White, like the color.
Okay. Mr. White, do you remember the what make, model, and serial number of the device you used was?
It's a LiDAR. I don't know the serial number. I would have to pull it out and look at it.
Do you know who the manufacturer of it is or any of those kind of information?
I'm not required to know who manufactures it. I just have to be certified in the operation of it.
By who?
I was just curious because it usually has a sticker on the side. You said that it's calibrated before your shift, after your shift, and each time you power it on. Is that correct?
We do not calibrate the instruments as deputies. Those are done annually. We run daily tests on them before we use the device to make sure they are functioning properly.
Okay. Do you happen to have the records of those checks with you here today?
We don't keep a running log of when we do check them, but at their annual certification, that is logged.
Do you have the annual calibration with you today?
I do not.
And you did state that it was tested at the beginning and end of your shift.
No, it was tested at the beginning of my shift.
All right. No further questions for this witness, Your Honor.
Redirect Mr. Baca.
Just briefly, Your Honor. Sergeant White, is the speed posted on that highway you were at in this area?
It's posted in several locations throughout that stretch of highway, yes.
And what is that posted speed?
It is 65 miles per hour.
No further questions, Your Honor.
All right, thank you. Any further evidence, Mr. Baca?
Your Honor, this time the state would rest.
Very well, Mr. Rumford, you don't have to present evidence, but you can if you wish. Do you wish to testify or present any other evidence?
I would like to touch on something that the sergeant said. He did mention
Well,
that
if you're
I
going
had
to hold on, if you're going to testify, raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, you may lower your hand. And you are Scott Rumford, the defendant herein, is that correct?
Yes, Your Honor.
All right, what would you like the court to consider today?
That Sergeant White mentioned that my girlfriend was having vehicular issues approximately 8 miles from where that traffic stop occurred, as well as she was broke down in the middle of Kellogg, which I believe we're all aware of how Wichita drivers are.
I didn't hear him say, hang on. I didn't hear him say all of those details. Are you adding those for me?
Yes, Your Honor.
I didn't hear him say anything other than she was broke down somewhere. Okay, or had issues. Go ahead, sir.
Correct. She was broke down in the middle lane of Kellogg, approximately 8 miles from the traffic stop.
Okay.
She had, to my knowledge, called 911. They were supposed to be sending somebody, but even after the delay of the traffic stop, I was able to get there and get them off of the road. I don't have photos of it, but there were several skid marks where they were almost rear-ended.
Anything else you want to say?
That is it, Your Honor.
Okay.
Going for the sympathy card is
I'm a
popper
professional truck driver. I average over 150,000 miles a year. I'm currently sitting in California. I have very limited
jurisdiction
traffic infractions on my record. This is a once, almost in a lifetime type deal. You know, I take my driving very seriously. I've never been in any accidents. I have over 1 million miles of safe driving. And, you know, looking back, I probably would respond a little bit differently.
Like pay the $25 for discovery?
All right. Anything else you'd like to say?
He's asking for sympathy now that he's wasted
That
everybody's
is it,
time.
Your Honor.
All right, thank you. Any other evidence you want to present, Mr. Rumford?
Not at this time.
Well, this is your time to do it if you're going to.
I don't have a way to submit it.
Okay. Anything, any rebuttal, Mr. Baca?
No rebuttal, Your Honor.
Any closing arguments, Mr. Baca?
Thank you, Your Honor. Very briefly, Your Honor, the testimony the court received today from Sergeant White, who is employed with the Butler County Sheriff's Department, and I asked the court to find that he is a credible witness. He has no bias, or outcome of this affects him in no way, whether the defendant is guilty or not guilty. So I do believe his testimony is very credible. He indicates he was at a location here in Butler County, Kansas, doing traffic enforcement, that his LiDAR was working correctly and was tested before testing the speed on the vehicle. And at that location in Butler County, he observed the vehicle driving 87 in a 65 mile per hour zone. Based on that, we would ask the court to find that the defendant is guilty of speeding 87 in a 65. While the state is not unsympathetic if what the defendant says is true about the emergency situation, the unfortunate business for him is that speeding is a strict liability offense. That statute does not say anything like you're allowed to speed if someone's in the hospital or someone's sick or otherwise. And so while I am sympathetic to his potential reasons, the officer's there to look out for the safety of others. This was a speed that was over 20 miles an hour, the posted limit. So we would ask the court to find that the state has met its burden today and find the defendant guilty beyond a reasonable doubt of speeding 87 in a 65 mile an hour zone.
Thank you, Mr. Rumford. Any closing argument?
Your Honor, I would like to basically state that I requested discovery. I did not receive it. Aside from Officer White's testimony here today, the state has not provided any supporting documentation, including the calibration records, and I would ask the court to find that the evidence is insufficient.
He's reading something.
All right. Final point. You asked for the discovery. You were told you could have it, but you had to pay a reasonable fee of $25, and you chose not to do that. So the fact that you don't have
Your
it.
Honor, I asked several times.
We are not going to argue, Mr. Rumford. The fact you don't have discovery is on you. It's your fault. And the fact that I didn't grant a continuance is your fault because you've had plenty of time to remedy this situation and do it the right way. Now, was the officer credible, as Mr. Baca said? I do find Sergeant White to be very credible and knowledgeable, and that his device was working properly the day of the stop. I have no reasonable doubt as to that. Like the state, I'm sorry your girlfriend was in that situation in Wichita. No, I wouldn't want to be there either, as she was broken down. And I can see why your concern for her and whoever her passenger was would cause you maybe not to be focusing on your speed as much as you normally would. I can see where you'd be distracted and that speed could creep up on you. But whether you did it intentionally or whether it creeped up on you unintentionally, you were speeding, as I find, and as the officer has testified to, 87 miles per hour in a 65 mile per hour zone. So I do find you guilty, and I order you to pay the scheduled fine and the court costs of $108.
108.
And I believe the scheduled fine is $123, but let me check. Mr. Baca, is that what you show as well as $123?
Yes, Your Honor.
231.
Okay. So your total due it's like $231. Do you need some time to pay that? I can give you time to pay it.
I can probably pay that within 90 days, depending on how quickly the company can get me back to the area.
Well, I'm going to give you 90 days to pay, but if you don't pay it by then, your license will probably get suspended, and that could be a problem for you. Call the clerk of the district court, and she'll tell you the online website, the mailing address, in-person address, the different ways you can pay that. You want to write down her number?
Yep, let me get that going here.
Okay, we're gonna wrap this up because we know the outcome here.
It's 316.
867-5309. 867-5309.
90 days. You have 14 days to file an appeal with the Kansas Court of Appeals. If you think I have illegally applied the laws in this case, you'll either need to hire an attorney, or if you want to represent yourself, you're going to have to know how to do that. And if you do file an appeal, I'm going to order that you pay a $231 cash surety bond. And I order that amount so that if you do not prevail on your case, that the matter can be paid out of that surety bond. And so that's why I'm ordering that.
And you said, what about a bond?
If you file an appeal within 14 days, you have to pay a $231 cash bond.
Just the same amount as your fees.
To cover the cost and fees that are owed during the pending appeal. In case you don't prevail, the amount is covered. Anything else?
Okay.
So you got to pay your fee.
I don't believe so.
Mr. Baca, anything further?
Nothing from the state, Your Honor. Just thank you to Sergeant White for being here.
Sergeant White, you are excused if you don't have any other cases on this docket. Mr. Rumford, you are excused if you don't have any other business with this court, as we'll be in recess at this time.
Thank you, Your Honor.
You're welcome. Thank you, sir.
No, thank you for Mr. Rumford. All right. We're gonna end it up there because apparently we might have a plumbing issue I need to take care of, which is never fun, but is always urgent. So I've got to go see what I broke or what someone else broke. I'm sorry. It was urgent. Sorry, came in and said, we have a leak. Yay. Use the bathroom last. All right. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. Please stay safe till we go live again tomorrow morning. It's going to be fun. I'm going to be back with the Judy Church trial. The prosecution is going to rest tomorrow. We're going to hear the ME. We're going to hear the notebook stuff tomorrow. The defense will get through probably most of their witnesses tomorrow. It's going to be a crazy day. Please join us for that. You guys be good to each other. We'll see you tomorrow. Bye-bye.
You are banished from the state of Georgia.
Thank you, sir. You're my new best friend.
What more do you need to see?
Scratch all that. That's terrible.
I don't like the podium, daughter.
It's not your turn to talk. I'll tell you when you can talk.
There's nothing in the order that restrains you from talking to cats.
You don't put a diplomatic plate on a hoopty.
In front of the Walmart.